Okay, cool. Hi, everyone. Thank you so much for tuning in. This is our first virtual event for our Justice for Survivors campaign. I appreciate you guys taking the time to watch this and be here today and to learn more about how Peace at Home's legal programs help survivors of domestic violence and intimate partner violence. For this presentation, our staff attorney, Ashley Norman, will be talking about the complexities of child custody, divorce, paternity cases, and how they are involved with abuse. Thank you so much for taking the time to talk with us today, Ashley.
You're welcome. Okay, are you ready to get started?
Let's do it.
All right, so I'm going to go ahead and share my screen here because I have a little PowerPoint that sort of goes along with. Oh, I don't know if it's going to let me do it. Can we?
Yes, Danny, will you come help me?
Well, as we get started, my name is Ashley Norman, and I'm an attorney, a staff attorney at Peace at Home. I've only been at Peace at Home for a few months, but prior to joining their legal team, I worked with survivors of domestic abuse for about 3 years before that. And I'm really excited to be here. Let me see here. Oh, I can do it now.
Good.
All right. Okay, so here we go. Okay, can everybody see my screen? Perfect. Okay, so what I'm going to be talking about today are the legal barriers, basically what happens when you decide to leave your spouse. And this, obviously, we've talked about a little bit before as part of our Justice for Survivors campaign. So all throughout the next couple of weeks, we're going to have lots of talks, different kinds of educational things going on. And we're going to have different overviews. I know Caitlin, Chad, a few others are going to do some more legal barrier discussions. Next week, we're going to have a free CLE. We're going to screen a movie and have a discussion about it. There may be some trivia and a lot of other things. So I encourage everybody who's watching to sort of stay tuned for the rest of the things that we have going on this week. And as I start, I sort of want to talk a little bit about Peace at Home. So Peace at Home is a family shelter. So we help anybody who's been infected by intimate partner violence. So gender doesn't matter, age doesn't matter. And our mission here, you can see, is to empower victims of domestic violence. So basically, and I underline this part because I think this is really what the legal team can help do. So by nurturing their self-determination and their courage. So what I see and what I've talked to y'all about recently is my favorite thing is just seeing these people, these victims start to heal, gain courage, be able to stand up for themselves. You know, these are the kinds of things that really why I like working with this company here, this nonprofit. So here's a little bit about our impact. So you can see some of the numbers here who were able to get to shelter, but specifically I bolded the legal services. It says that we were able to help 358 individuals through our legal services. So divorce, child custody, orders of protection, all of those things we're able to help with. So on average, you may know this or not, but on average, it takes the survivor 7 attempts to permanently leave their abuser. So the reasons for this, and I think that we'll probably go into this more specifically when we watch our video later on this week, but some of these reasons why they may leave is they're afraid, obviously. They are like 75% or more likely to be killed by their abuser while they're trying to leave. So while they are trying to leave, they're actually in much more danger than they are when they stay. Some of the other ones are the abuse is not constant. It's not happening all the time. And you'll see next, and you may have seen before, this wheel that it's good, then bad things happen, that, you know, we go through this cycle. And so it's not abusive all the time. So they're hoping maybe they really will change this time. They told me they're going to change this time. Maybe they will. You know, having children is a huge one. You know, you don't know, like, financially, how am I going to care for my children? Is he going to take my kids? You know, all these types of things. And obviously the economic dependence on the abuser. And oftentimes you are isolated. The abuser keeps you from talking to your friends and your family. You don't have anywhere to go. There's all these things, and y'all can read over it a little bit, but these are some of the reasons why they may not leave. And here's that wheel that I was talking about. So, it sort of starts, we're sort of starting to, the tension starts to build, things start to get bad. And then there's some kind of an explosion. There's, hitting, choking, imprisonment, not letting you leave your house. And then something bad happens. And then all of a sudden we go through this honeymoon phase where I'm not going to do it again. I'm, blah, blah, blah. And we just keep going around. And one of the other barriers, obviously, that we're here to talk about today is the legal system, right? So the survivor may not know, just because unless you've been involved in a divorce or child custody case before, you may not know what happens. And also, a lot of people have misconceptions about what happens during a divorce or a separation. A lot of times these misconceptions are encouraged by the abuser. So, hey, leave me, I'm going to take the kids from you, and so she's afraid of what is the judge going to do. Caitlin specifically is going to have a discussion on how abusers can use the legal system to keep abusing, basically. So that should be really interesting. So I would encourage everybody to listen to that one too. But what I want to do today is sort of briefly go through what happens when you do decide to leave. That way, just to give a basic knowledge of this is, normally what happens when I get an order of protection or when I get a divorce or when we go through a child custody, just to maybe break down a little bit of that barrier of the misunderstandings or, lack of knowledge about what is going to happen. So I'm going to go through briefly today, and this is meant to just obviously be a super brief overview. Every case is different, and there's lots of little things that can go on in each one of these cases, but I'm just going to sort of go through them and give everybody an idea of the basic concepts here. So the first thing is an order of protection. An order of protection orders that the abuser stay away from the victim, away from where they live, where they go to school or where they work, that they don't have any contact, any way, shape, or form. So this often can be someone's first interaction with the legal system, because it is something to immediately keep you safe, right? To order that he or she, the abuser, stay away. I put on here sort of the purpose. This is taken directly from the statute for an order of protection. It's basically to keep the citizens of the state of Arkansas safe from future abuse when there has been past abuse or threats of abuse. So an order of protection is different from a no contact order in a criminal case. So oftentimes if there's abuse, there's a criminal charge for that abuse, and the police or the judge in that case will put in a no contact order. This order of protection is different. This is a civil case, and it does order that the person stay away, but it's not part of the criminal case. So the no contact order in the criminal case can go away if a judge says it goes away. The prosecutor could have it go away, but this order of protection stays in place for however long the judge says. So it doesn't go away until the date of that final order has gone. To file an order of protection, you will go to the clerk's office, the circuit clerk's office in the courthouse in whatever county you reside in. You can file it where you're living, where the abuser can be served, or where the abuse happened. So you may have a situation where all of these things is the same county, but you may have a situation where someone is fleeing, is going to stay with somebody else to stay safe. You can file it wherever you happen to be at that time. So if you have gone somewhere to stay safe, you can file it there. You'll fill out some paperwork, and they will give you a hearing date, basically. So before that hearing date, you'll either have an ex parte, which is an order saying that this person must stay away from you until the date of the hearing. Sometimes the judge does not give an ex parte. They will just order a notice of hearing. So they just give you a hearing date. And whether you get an ex parte or a notice of hearing is based on what you have written in your affidavit. So when you go to fill out an order of protection, you'll basically just write your story down. This is what happened, whatever. And the judge will read that, and based on those allegations say, yeah, you need some protection until I can hear this matter, or no, I don't think enough has been alleged. We're just going to do a notice of hearing. Regardless, you'll have a hearing, and on your hearing date, you'll present your evidence, and the judge will decide whether you are entitled to a final order of protection. An order of protection can be entered in anywhere from 3 months to 10 years. And 10 years is just the max. That's just what the law says. So if at the end of that 10 years, you are still in danger or something else has happened where if you need another order of protection, you can ask for another, but 10 years is just the amount of time that they're going to give you at once. Chad is going to give us a talk later on this week that's going to go really in depth about how to file that order of protections, what you want to put in your affidavit, that kind of thing. But this is just a basic overview of what happens. And it normally is your first stop, your first encounter with the legal system. So divorce here. In a divorce, the judge or all these issues are going to be dealt with. So property, debt, alimony, child support, child custody, all of it is going to be decided. If the parties don't agree, the judge is going to be the one who makes that decision. So basically the process, just an overview, is you will file for your divorce. Then you will serve your spouse. So meaning that's when like a sheriff or a process server goes out there and finds them, gives them a copy of the divorce. There can be a temporary hearing if necessary. So that is after the divorce has been filed. If we need to figure out what to do temporarily with the house, child custody, child support, we can have a temporary hearing. And then oftentimes we move through what's called discovery. So this is when both sides try to gather evidence. So we can send the other side questions. And what I see a lot of is an abuser has kept somebody from the finances. They have no idea how much money, where it is, what's going on. There's things that we can do, questions we can ask to figure out where they work, how much they make, how many bank accounts do they have, what's in those bank accounts, do they have a retirement account, what's in that retirement account. So we have ways to find out that information. So we'll sort of go through that process. Once that's done, occasionally a judge will order what's called mediation. And this is sort of like an informal, you guys go to try to work this out. Sometimes it works, sometimes it doesn't. But if it doesn't work, it doesn't matter, you still go on to the final hearing. The final hearing is where the judge makes those determinations. So anything you all agree upon, the judge will say, that's wonderful, I'm glad you agreed, and enter that into the order. But anything you do not agree on, that's what you'll put on your evidence, and the judge will make the ruling. Okay. And so by the time you're done, the judge will have split up all the property, all the debt, done child custody, visitation, child support, anything else that needs to be dealt with in your divorce will be done that day of the final hearing. Now, and we'll go into this a little bit more, anything to do with child custody can always be modified. So there's a chance in the future that if something changes, you can modify your divorce decree as it goes to the children. And everyone always wants to know how long it takes. It just totally depends. So if you and your spouse agree, we don't have any kids, we already know how we're going to split up the property. A divorce only has to be on file for 30 days before it can be finalized. So best case scenario, 30 days, but that's rare, right? Most of the time there's something going on, discovery we need to do, hearings we need to have, it's going to take longer. And oftentimes that's really just at the mercy of the court's docket. So we might want a final hearing, but the judge is like, sorry, I can't get you until October. And there's really nothing you can do about that. So one thing I do want to say is that you do not need an attorney to do a divorce. Okay, you can do it yourself. So if you and your spouse agree, and I'm going to share at the end some resources that are safe, reliable resources if you would like to do your divorce yourself, that you can trust the documents that come from these places. But oftentimes having an attorney is helpful, especially if there's going to be a lot of contested issues. And again, I'll share some resources. Obviously, we do these here at Peace at Home, but there's some other organizations too who do divorces for low, minimal cost for survivors of domestic abuse. Okay, so in Arkansas, you technically need grounds to be divorced. So there's no like, whatever that one is that everybody always wants to do. That we don't have that. Okay, you have to have grounds to be divorced. So I listed a couple of them here. The most commonly used one is general indignity. So basically, this is what a lot of my clients use. So basically, he's treated you in such a way that you can no longer, stay married to this person. So that would include physical, mental, emotional abuse, those types of things. Another one is separation for more than 18 months. So the only way in Arkansas to get a no-fault divorce is if you've been separated for more than 18 months. So everybody comes in and they're like, well, I just want a no-fault divorce. Well, you can't do that in Arkansas unless you've been separated for more than 18 months. The main thing that most people want to know about, I think, in divorce is child custody. So in Arkansas, there's multiple different types of custody. First, there's joint custody. Joint custody is when both parents spend roughly the same amount of time with the children. So almost 50-50, pretty close. A lot of the times when there's joint physical custody, there's also joint legal custody, which means both parents are able to make important decisions for their kids. So important medical decisions, educational decisions, those types of things. Primary custody is when one person, the child lives with one of the parents most of the time, and the other has some kind of visitation. So most of the standard visitation is like every other weekend, sometimes a midweek, that kind of thing. Sometimes with that, one party may have legal custody, one parent may be, you make all these important decisions, or it can still be both parents. But this is something that can look so different depending, right? So a lot of times, given the situations, there can be supervised visitation where one parent only visits the child when under supervision of somebody. If there is a potential issue with alcohol or drugs, maybe one parent only visits during the daytime when they are less likely to be intoxicated by whatever. This can be changed to go with whatever situation we have going on. So when the court determines custody, they're looking about, at what is in the best interest of the child. Okay. And there are specific factors that I've listed here that the court through cases has said, these are the kinds of things we're going to look at. So like stability and living conditions. And I will say that if you are a survivor and you are maybe not quote stable because you are trying to find a place, that's not going to be held against you. Okay. So just because you don't, you haven't lived in one house for the past 15 years, that isn't going to be held against you. But they're going to look at your living conditions. Did you have a safe place for your child to live? Did you have water? You have electricity, the things that you need. They're also going to look at the love, care, and affections and guidance provided by each parent. And they're going to look at their moral character. So this can obviously include problematic drug or alcohol use. You can ask the court drug test your spouse if you think that that's an actual concern. And this next one is important. So if a parent is found to have committed acts of domestic violence, there's a rebuttable presumption that it's not in the child's best interest to be primarily placed with that person. So a rebuttable presumption means that it can be overcome, right? So somebody could put on evidence to overcome that presumption, but they're going to have to do that, right? There's already a presumption if you've committed domestic violence, either against your spouse or against a child, it's not in the child's best interest to be with that parent. So that's an important thing I want survivors to be aware of, right? Because that's one of the common things like, well, I'm not going to let them, you don't have a job, I'm not going to let, you're not going to take the kids. But we do have this rebuttable presumption in Arkansas if the other parent is a domestic abuser. Same thing. So if that parent is a registered sex offender, the same presumption applies. The court will look at what a kid wants to do, but only if they're old enough. These other things, so past estrangement. So if one parent is like keeping the child from the other parent without a court order, that's not a good thing. And then fault in a divorce is not necessarily a factor in awarding custody, right? So just because so-and-so cheated on so-and-so, that has nothing, that's not going to be the main factor in custody. We're going to look at these things, which the fault in the divorce may play into those, right? Like you may, the domestic abuse or the moral character or whatever, but that's not going to be the main factor in deciding custody. So joint custody, sorry, I'm going to go back to the other slide. Joint custody is favored in Arkansas. So the way the statute's written, the judge will try to do joint custody if that's possible. But, they're going to look at all those factors to do what's in the best interest of the children. The next thing the court is going to do is look at property. So most of the time, at the time when the divorce decree is entered, all the property is going to be split up. So it's normally 1/2 to each party, unless the court for some reason finds that inequitable. Okay. So what the court can look at all of these things that I've listed here. How long they were married, the employability, all these different types of things when they split up the assets and the debt. As far as debt goes, the court is going to equitably split up that debt as well. But normally how it is, so like if you get this car, you need to have the debt that goes along with this car. If you get this stuff, you get the debt that goes along with that. But this is something that can be so different depending on the divorce and the different facts, but the court will make sure all the property is divided. I was going to say something else. So a lot of times, like let's say we can't figure out, we can't agree what to do with the house, we can't agree, whatever to do with this. If we can't figure it out and we can't figure out a fair way to do it, then what the judge is going to do is order that property sold and split the proceeds if there are any. But the property is just really something that depends on what you have. Anything acquired during the marriage is considered marital property. Anything that you had before the marriage or anything that you got by like a gift or inheritance during the marriage is your separate property that you get to keep. It's not considered marital property. Alimony or spousal support. This can be something this will be dealt with in the divorce as well. It can be temporary or permanent. So it could be temporary for just a period of time to help somebody get back on their feet. So it could be like for a couple years and then it goes away. Or it can be permanent, which means it lasts, until that person dies or the other party gets remarried. So like I put on here, there's no guarantee of spousal support. You have to prove it. And the main concern what the judge is looking at is one party's ability to pay and the other party's need. So you have to show a need for it. And then you have to show the other party's able to pay it without totally impoverishing themselves. So these are the factors that the judge looks at. Past living standards, financial circumstances of the parties, their income, are they able to go make money, medical and health needs of the party. Fault in the divorce only plays in when it relates to somebody's need or ability to pay. So for example, if a wife has a business, husband came in and totally destroyed this business, so wife can't make money for a set period of time, the judge may award alimony on a temporary basis to help wife get back up on her feet and start being able to make money again. Now, there's no set amount of time you have to be married to get alimony, but the longer you're married, the more chance that you have that you would be successful in getting alimony. Child support is our next thing. So child support in Arkansas now is based on both parents' income. So I put a little example of the chart here, but there's a whole little calculation that you do. So you put down how much parent one makes, how much parent two makes, and it does this little calculation for you. I put a link on there too that you can go through or go to, and it tells a lot about what income is considered in child support. And this is another thing that so much more goes into it than like the paycheck you get at the end of the, so many things can be considered income, and too much to go over right now. There's my kid. If one party is not working, and they're able to work, so they're just not working because I'm not going to work, I don't want to pay you child support. The court is going to say, no, that's not acceptable. I'm going to impute your income to whatever I think you're able to make. Now, sometimes that's a full-time minimum wage job. Sometimes it's higher based on their skills, but the court won't allow somebody not to not work and not still have to pay child support. You can't say, I'm not working, you can't charge me child support. That's not true. Okay. It may be different if the person has a documented disability, they're getting some kind of Social Security. Sometimes they're not required to pay at that point, but somebody can't just try to avoid it. Child support can be modified. So if a party has a significant change in income, you can either through an attorney or through the Office of Child Support Enforcement ask for it to be modified. I think at the end, the resources, I put the Arkansas Child Support Office link in there. That's a really good resource because if you're trying to start child support, or they will help you do it, and they have a lot of good resources on how to do it. Okay, so this is sort of what I was talking about before. Any order relating to child support, child custody, whatever, can always be modified. So modification of an order can occur if there's been a material change in circumstances. So this is like normally the parent does something wrong, right? All of a sudden there's some drug and alcohol concerns that weren't there before. There's some criminal charges maybe that weren't there before, some abuse, that kind of thing. And you can ask the judge modify the child custody order because of these changes. Sometimes the changes aren't really something somebody did wrong, like maybe one parent has some significant health issues now, or one parent wants to move. Like, doesn't have to be a bad thing, but child custody can always be modified. So, if you're concerned about the visitation that's going on, it doesn't have to be forever if it doesn't work out, I guess. So let's say that you were not married, but you did have a child. So, I mean, this obviously, these people, even if you're not married, you may be separating from your longtime partner and you share a child together. So in Arkansas, if a child is born out of wedlock when you're not married, custody automatically goes to the mom unless a court says otherwise. So it does not matter if dad signed the birth certificate, if he's on some acknowledgement of paternity, y'all wrote up something and had it notarized, doesn't matter until a court, like you go in front of the judge and the judge signs something and says, yes, so-and-so is the legal father. Okay, and I think that that's another, I'm sure they're going to talk about this later next week, but that's another thing, like, oh, you can't take my kid from me, that's parental kidnapping, or, whatever. Unless there's a court order that says what custody and visitation is, if a child is born out of wedlock, custody is with mom. Okay, and so that's important to know both ways, right? So if you're a dad who, is all of a sudden getting cut out of your child's life, you can also go to court and file for paternity. So mom or dad can file for paternity with the circuit court to get custody visitation rights. So dad may want to, if he's not being able to see his child. Mom may want to get something in, in a court order set visitation. DNA testing can happen if you need to. If both parties agree, the judge won't make y'all do a DNA test. If you don't, if either mom or dad disagrees about the relationship with the child, you can ask the court to do a DNA test. Once it's determined who the legal parents are, the same custody factors as we talked about before apply. So you're going to go through all those set of the best interest of the child factors. And the court, unless you agree, the court's going to determine the custody and visitation schedule and start child support. So that's pretty much all. That's pretty much all that I have to go over those. Here are some of the resources that I had. So obviously here's our website, Peace at Home. Caitlin and I are the attorneys there, and we assist people who have been victims of intimate partner violence in all sorts of legal proceedings. So orders of protection, divorce, custody, custody modifications, paternity, lots of different things. And we're able to provide those services at no cost to our clients. So that's another good thing to know. Legal Aid of Arkansas is another one that is in our same geographic area, and they also support survivors of domestic abuse and take a lot of family law cases in that arena. And they do have an income like maximum. Basically, if you make too much money, you may not qualify, but they're able to provide legal services at no cost to the clients as well, or limited cost. And also this other third resource there's a bunch of fact sheets on there, and they are a resource that you could trust. They have them about family law stuff and all sorts of different kinds of stuff in Arkansas. That's a source that you could trust. It's going to give you good, brief legal information, sort of easily digestible, but that's a good source, because I know a lot of people find some online divorce thing, and I've seen a lot of people come in and they're not right. So I don't want you to spend money on getting those documents and they're not reliable. This same one here with the fact sheets, they do have some pro se forms, which means if you're going to do something without an attorney, they have some forms that you can look at and use or modify however you need to. And those would be trusted forms that you can use, and they're free. So I just see a lot of people who pay for these things and then they bring these in, and I think there's nothing you can do, and you just wasted like $500. Child support, there's the resource there. You can go there. It has a lot of good questions, frequently asked questions about child support and what to do, when you can start child support, that kind of thing. And if you really just love to learn about Arkansas legal, Arkansas law, there's a bench book on there. And so this is just a resource, but it's what the judges use basically to get brief overviews of what to do in a paternity case or a divorce case. And so it's really good, just like brief overview if you're interested in that. I put my email on there in case anybody has any questions that they want to ask. They can email me, but I mean, obviously this was just sort of supposed to be a brief overview, and it's just been me talking to you for like 30 minutes, but hopefully it's helpful. And really the purpose is just to give you an idea of what to expect. So you're not going in there blind, and sort of take that kind of question out of it when you do decide to separate. So do any of you have any questions? No? Okay, well, that's all I have for today. So
Perfect. Thanks, Ashley.
yeah.
Okay, I'm going to remove your spotlight, and you can stop screen sharing if you
Okay.
want. But thank you so much, everyone, for watching this and tuning in. Last year, we paid $37,000 of court cases for our survivors. So our legal team are superheroes, and we're so thankful for everything they do. So thanks, everyone, for tuning in. And I'm going to turn our recording off now.
Okay.